Evening, my name is Ivy. I'm going to be presenting on European Convention on Human Rights, which is ECHR, and the Human Rights Act of 1998. My presentation is going to cover the scope and application of the ECHR on human rights, the Convention on Human Rights. I'm also going to analyze civil rights protection that are afforded by the convention. I will look at the impact and interrelationship of some of the convention rights, and the impact of Human Rights Act of 1998, constitutional impact, and also the impact as a means of protecting civil rights. In some of my analysis, I'll also cite some of the recent cases in the UK. The scope or an application of the European Convention for Human Rights. This is an international treaty which was put into force in 1950. And it's a mandate to all member states of the Council for Europe, and the human rights are enforced by the European Human Rights Courts. It also gave the individuals the right to challenge any human rights violations. The convention also laid down all the freedoms and rights by each member state to make sure they safeguard individuals from any form of violence. The convention became law in the UK through the Human Rights Act of 1998. This meant that the human rights cases could be heard in the United Kingdom. Public authorities were also mandated to respect the human rights. Individuals had also they now have a right to challenge any public authorities against any human rights violations. There's also no need for them now to go to ECHR because the United Kingdom, the UK Human Rights Act has been put in place. This also helps to prevent human rights abuses, and also mandated the courts to review any decisions by the government to make sure that they are complying with the ECHR. Some of the civil rights protected by the convention include the right to life, which is Article 2, right to freedom of expression, which is Article 9, right to liberty and security, Article 5, and right to freedom of thought, belief, and religion, which is Article 10. Those are the convention rights, that civil protection rights that I'm gonna look at. The civil rights protection under the CEHR, they created a legally binding obligation on each member state to make sure that authorities respect human rights. It also it allowed individuals to petition the European courts for human rights in the event that they are human rights violations, and the member states have been given a legal responsibility to make sure that they comply, and the governments do not abuse power. There are two obligations that I looked at. There is a positive obligation to authorities, and there's a negative obligation, where the positive obligation means that the authorities are mandated to take reasonable steps if there is a threat to life that is known. A negative one, it means that authorities are not supposed to interfere with any fundamental rights unless if it is justified. Then I'll look at the right to life, which is Article 2. The right to life, it is considered as an absolute right. This right, it means it cannot be limited, it cannot be restricted, it cannot be interfered with. No person or government is allowed to end life. It mandates the government to safeguard life through putting laws in place that will protect lives. And it also mandates the authorities to investigate any suspicion or suspicious death. This right, it's not only to specific authorities. Any person or people in authority, which can include the police, the prisons, the army, the air force, healthcare, everyone has the right to protect life. And if there is a real and immediate danger or threat to life, they have a mandate to make sure it is prevented by all costs. However, the right to life can be breached, and a person can die when the authorities use force under circumstances like they are trying to restrain someone who is trying to avoid detention, or stopping someone who wants to cause violence, riots, or uprising. However, if they have to breach that, it needs to have a justification to it, and they follow the rules and regulations to the book. Right to liberty and security, which is Article 5. Everyone has a right to express themselves, and right to liberty and security has a right to know the reason why they are being detained. Without any justification, they cannot put a person in prison. However, there are exceptions where restrictions are put in place. For example, if it's old people's homes, they can put locks and restrict them from going out. Any person with no capacity to make decisions, it can be legal for them to be deprived of their liberty and security as well. Preventing someone from committing a crime, then the person is detained. That is also allowable by law, as long as it is done the right way. Detention of minors under educational supervision, that is also acceptable. However, any detention that is going to be done, it has to follow legal procedures, and it has to be justified. The relationship between Article 2 and 5 is that if the state deprives someone of liberty through maybe detention, or they've been put in prison, the state still has a right, is a mandate to protect and make sure they are safe, protect their lives. If someone dies in custody, a case might be raised under Article 2. For example, in the case of Alan Marshall, who died in prison in 2015, in custody, in remand, and in 2015, the court wanted to establish whether the authorities were in breach of Article 2 by failing to prevent or protect life of a detainee who is Alan Marshall. The fatal accident inquiry then concluded that the death could have been prevented. So the authorities were found to be in violation of Article 2 because of restraint failures. So under the Article 5, when the authorities detain a person, it meant that their freedom is restricted. It then places the higher responsibility to authorities to make sure that the person's life is protected, which the authorities did not do when they detained when they restrained Alan Marshall. Right to freedom of expression. This is where a person has a right to express their opinion and share information. There are also exceptions to it, which include if whatever they want to express or they want to share is a threat to national security, that can be an exception. When they are exercising their rights, they have whatever information they want to share, it incites violence or crime, that is also another exception. If it's also a threat to health and more people's morals, it's also an exception. So criminalizing statements such as, this is just an example, such as the terrorism statements or supporting terrorism is not regarded as a breach of freedom of expression because it is a threat to national security. Right to freedom of thought. This one is a right where each person has a right to believe in whatever religion or practice it in any way they want to do it. However, if whatever they are practicing or their belief is a threat to public security or public disorder, then sanctions can be imposed by the state. For example, a case of TTT and Michaela Community School Trust in 2024, where a student wanted to hold ritual prayers in school during lunch break. Then the school had to impose policy to ban the religious practices or activities within the school. So the student took the school to court, and the court then concluded that the policy that was put in place by the school did not breach Article 9. So the courts looked at the balance between the beliefs and the manifestation of the religion, where they said it can be lawful for the school to interfere lawful for the school to ban it is lawful for the school to ban it because it interferes with school order. So really any religious practices that involve expressive conduct, this could be maybe you are singing or you are playing music of your religion within the school, for example, there could be restrictions that are put in place. Some of the rights that overlap, which I looked at Article 2 and 10, where any speech that promotes violence or crime can be restricted to protect lives. The second one is Article 5 and 10, arresting protesters balances liberty with public order. However, even if they are arrested, they need to be protected, right to life. Article 9 and Article 10, religious beliefs can be expressed in public. 5, 9, and 2, prisoners, irrespective, or detainees, irrespective of their cases or circumstances, they have a right to practice any religion of their choice. And at the same time, the state has a right, has a mandate to make sure their lives are protected, even if they are criminals. The constitutional impact of the Human Rights Act, the impact of the Human Rights Act on the Constitution, there is a positive one and the negative. The positive one, it means that the human rights were brought home. When this was introduced, the human rights were brought home, which then reduces the need for individuals to go to appeal in the ECHR. Everything now is done in the United Kingdom. It instills the human rights culture within the country, which then gave the authorities a mandate to make sure that when they are developing policies and making decisions, it has to be centered around human rights, or to make sure it protects human rights. Protection of rights are enforced, therefore increasing justice to people. So it means because there are a lot of courts within the United Kingdom, everyone has access to justice. Enforcing the constitutional impact as well was to make sure that there is standardization in human rights across the UK. They follow the same rule, the same procedure, the legal procedure in the UK, which makes it uniform. It also cuts down on delays. and cost for individuals having their cases to be taken up to ECHR, they now can be heard within various courts within the United Kingdom. The basis, it also forms a basis to review executive decisions and actions, which means the executives or the lawmakers is also, they can be questioned. Their decisions are also analyzed. The negative impact, it displays the growth of emphasis on human rights. It displaces the responsibility and focus on responsibility and the public interest. And there is also legal uncertainty and risk aversion, where there is a confusion between maybe interrelated rights. For example, Director of Public Prosecutions versus Ziegler case in 2019, the courts persecuted the protesters. However, the courts then, the ECHR, due to ECHR rights, the decision was overturned because they felt that the human rights were being violated. This made the public service to be more cautious at the expense of public interest. Now, because of some of these complications within the rights, it meant that public authorities now trade with caution. They don't execute their jobs without maybe having sort of a fear to interfere with human rights. The courts interpreting ECHR, it influences policy making. That's creating a bias. This means that interpretation of the ECHR law can then create a democratic bias, because the interpretation by policymakers can be a bit different. Over-dependent of the ECHR in the UK, it alters the domestic balance of power between the parliament, judiciary, and the executives. The Human Rights Act as a means of protecting civil rights. Enforcing the rights in the UK reduce the legal cost. Cases are not delayed anymore. The individuals have more access to justice. Authorities then makes it unlawful for all authorities to act in ways that are not compatible with human rights. So if they do anything that is not compatible with human rights, it's unlawful. The legislation, when they are interpreting it, it has to be in line with the Human Rights Act. It also places accountability to government, promotes transparency as well. The weaknesses include it is perceived as an overreach, which means the decisions can be overruled by the courts, decision made by the authorities. There is also financial burden on authorities as they are trying to defend human rights. There could be litigation, they could be settling or human rights claims as well. The conflict with other rights can create a confusion where, for example, right to privacy may conflict with right to freedom. And in conclusion, human rights acts are very important and fundamental in the protection of human rights in UK. The Human Rights Act is very fundamental. Despite its challenges, it has provided a balance between individual rights with public interest. Its effectiveness, however, is dependent on the cooperation of the lawmakers and the careful interpretation of the law by the courts. I thank you.